Hi folks, and welcome back to Contract Law. This is the video series on discharge of contracts, and I sometimes call this video series the series on death of a contract. A little bit dramatic, but it kind of fits, if you think about it, with the way that this unit evolves. So the first half of the unit, we look at contract formation, which is kind of like, the baby contract gets born. We look at all the necessaries that you have to have, the 3 Ps, party, property, price. So obviously, consideration, all of those other prerequisites that support all of that, like capacity and intention to contract. We had a look at privacy. When the contract's on foot, greater understanding develops. We had a look at terms, express terms, implied terms, how you construe terms, whether terms were really important and therefore conditions, or whether they were simply warranties or sitting somewhere in between the two, which are innominate or intermediate terms. So that's kind of the birth of a contract and kind of like a toddler and growing up. And then we had a look at the vitiating factors. So this is some of the ways that the dark side kind of cuts through, and you've got my little Grim Reaper there with his knife out. Any of those vitiating factors may well result in the contract being rescinded and therefore of no effect between the parties. And today's video series is really just putting the final nail in the coffin, I guess, looking at all of the other ways that a contract might come to an end. We call the umbrella term for that is discharge, but there are a number of different ways that the contract can be discharged. These are the ones we're going to have a look at today: performance, agreement, frustration, and termination. Although there are quite a few more, I'll leave you to potter about in the text if you wish to flesh out your knowledge of those other ones that we're not going to cover in detail today. If you want some more reading, my word, there are a lot of readings that I can certainly provide for you. So just shoot me an email if you wish to know more. So this is just, I guess, dipping our toe in the proverbial pool of discharge, if you will. So the first one that I want to have a look at is performance, discharge by performance. I guess the first thing to do is to start off on one of the few positive notes of today's video series, and to say that a contract might actually be discharged quite happily by satisfactory performance. If performance is all good, there's no complaints, the parties have performed exactly as they are meant to do in the contract, then it's all happy days. Everyone's a winner. Everyone gets what they've bargained for, literally, and the contract's at an end. There's a finish line in sight. Everyone gets across the finish line, and everyone's happy. High fives all round. But there's not a whole lot of disputes there, really, is there, if everything goes well? Not a lot of money that lawyers can charge. So then we look to the areas for dispute. And one of the first areas that consistently crops up is where performance is unsatisfactory because of something to do with time. A time stipulation has been missed or not observed, and that's the real bugbear between the parties. If time is the issue, then there are a number of things that you need to note. Firstly, you need to ask yourself, is there a date specified in the contract for performance of that particular obligation? If there's a date specified, then you've got to say, is time of the essence? That is, you've got to ask yourself whether the contract itself or something implicit in the facts tells you that time is an essential condition between the parties. If that's the case, happy times, you can terminate for failure of that time stipulation and you can sue for damages. But you need to be a little bit careful here. Don't go too gung-ho. At common law, if a date is specified, yes, it will generally be treated as of the essence, and you can go ahead and terminate and sue for damages for failure of that time stipulation. However, as you can imagine, failure of a time stipulation sometimes by only a matter of minutes, like in the Union Eagle case. If that's going to actually allow one of the parties to terminate, it might cause a fair bit of hardship. So generally speaking, in equity, time, even where a date is specified, is not considered to be of the essence. It really has to be expressly stated in the contract before equity will treat the stipulation of a date as being a conditional of the essence between the parties. Or there's something else in the context that makes it absolutely clear that it's meant to be essential. So at common law, yes, time will always be of the essence. In equity, no, it won't be of the essence. If the equitable rules prevail and time is not only of the essence and it's only a term, or a warranty, I guess you'd say, then obviously you cannot terminate. You can sue for damages if it causes loss, but you can't terminate. As to getting the contract price, you might be able to do that if there has been substantial performance, and that's something that we'll look at in just a moment. Nowadays, in most jurisdictions, you have legislation that actually applies the equitable position in most circumstances. So Section 62 of the Property Law Act in Queensland says stipulations in contracts as to time or otherwise, which under rules of equity are not deemed to be or become of the essence, shall be construed and have effect at law under rules of equity. So generally speaking, the fairer, more fuzzy, friendly, equitable position will apply unless you've got something in hard on black and white there in the contract. So that's where a date is specified. If there's no date specified, then the position is a little less clear between the parties. When do you actually have to render your performance? Well, you just have to perform within a reasonable time. And as you can tell, it's a bit like how long is a piece of string. I'm thinking particularly of the Lorinda and Capalaba Park Shopping Centre case here. The court will have to go through the facts and dig through and work out what it thinks is a reasonable time that performance should have been tendered within. If there's been a breach of that and the party hasn't performed within a reasonable time, it'll just be breach of a term. It won't be breach of an essential term, so you can't terminate. Okay. You can sue for damages, and again, you might be able to get the contract price depending on how you've performed in the circumstances. Now, if a party delays and delays past that reasonable time, does the other party just have the choice of putting up with it or potentially just suing for damages? Is there any way that you can get out of further performance in that kind of situation? Is there some way that you can terminate? Good question. What you need to do in that kind of a situation is serve a notice to complete. Now, the Lorinda and Capalaba Park Shopping Centre case that I was talking about before looked at notices to complete. And in that case, the High Court said that there are 4 things really that you need to have in order to have a valid notice to complete. You have to have an unreasonable delay already in the other party's performance. So where there's no date, that reasonable time has to go by first, and then you can serve your notice to complete. The party serving has to be ready, willing and able, and we'll talk further about that later on in this video series. They also can't be in breach of an essential term. Then what that notice to complete has to do is basically very clearly communicate to the other party, we think that you're in breach. This is what you have to do to rectify the breach that is performed. They have to give that further reasonable time for performance, and then that notice has to say, if you don't perform within this reasonable time, then we will treat the contract, for example, as at an end. Okay, so you have to set out the consequences of failure to comply. If you've got all of those things, happy times. You serve your notice, you wait your further reasonable time, And if the party does not perform within that further reasonable time in the notice, then you can finally go ahead and terminate. So that's termination for time. Now, the problem with performance does not have to do with time, but it's something else. Then the position is a little bit more complicated, and we need to do a fair bit of thinking about the contract itself and what the parties have done. And so to cover that in detail, what I'll do is I'll finish off this video here and I will go across to video 2. So, bye for now, guys.